Good afternoon, everybody. My name is Bill Walker. I'm an attorney who practices law here in Nevada County. I was in the Public Defender's Office for Nevada County from 1983 until the year 2003. And as part of that employment, what I did was participate in actually starting some of the drug court programs that we'll be discussing today. And I've participated extensively in those drug court programs since, off and on, both in my office and then since I've left that office, I've also stayed in touch and I have clients in those programs regularly. I wanted to talk today a little bit about the alternatives to just locking people up for their criminal behaviors involving substance abuse. Primarily at first, what I want to do is just kind of follow the outline that I handed out. It's a fairly information-intense handout, and what I wanted to do verbally is just kind of provide an overview of the information that's in that handout, and then kind of move through some of the other treatment options that are available here locally, and then turn it over to questions that y'all might have about this area. First of all, what happened was that California started in the early 1990s experimenting with moving away from a punishment model for people that just had simple drug possession offenses. We started a thing called diversion, and in the original form of diversion, the defendant would have a criminal charge pending, but he or she would not be required to enter a guilty or no contest plea. While the charge was still pending, the person would be diverted out of the criminal system into a treatment system. That model was extremely successful. It really was, especially here in Nevada County. We rarely saw those people back in court. However, the legislature saw fit in its wisdom to actually kind of tinker some more with that program. They added a domestic violence diversion program and some other check writing diversions. And those programs were, frankly, a little less successful than the drug diversion programs were for a lot of reasons, primarily because of recidivism. The folks writing bad checks would still have financial problems. The domestic violence folks would still be in relationships which generated problems. And so those folks came back before the court more often than actually the drug divertees did. And so based primarily on those other programs, the legislature revisited the entire diversion subject, and they changed it to what we currently have that's called deferred entry of judgment. And that's on your outline as DEJ. And DEJ is actually a whole scheme of statutes in the penal code that delineate a process by which a defendant can be prosecuted for simple drug possession charges and under certain circumstances receive some treatment and then thereafter have the charge dismissed. The primary difference in this evolution of DEJ is that the defendant has to admit the truth of the charge by way of entering a guilty plea. There is no provision for somebody participating in DEJ with a no contest plea. And the primary difference, for those of you who don't know, is a no contest plea says, look, I don't want to contest or fight the charges, but I understand that there's enough evidence that might prove my guilt at a trial. And so rather than run the risk of receiving a harsher sentence, I'm willing to get convicted based on a plea agreement or based on participation in some program, for instance. Well, that's not available in DEJ. You can't plead no contest. You have to actually prove or admit the truth of the charge and enter a guilty plea. But once you do that, then primarily what happens is the court, in a procedural sense, suspends sentencing. And instead of placing you on probation, what they do is they just delay sentencing and they place you into this DEJ program. And each county is allowed to have its own requirements or criteria that have to be met for successful completion of DEJ. In Nevada County, for instance, you go to one of the local providers and complete a fairly minimal, really, in my opinion, drug education class and treatment program. You are subject to testing. You are required to contact a probation or a supervision officer if you're told to. And if not, then you don't have to do that. But you do have to show proof to the court that you've completed successfully your drug education and treatment program. And you have to keep the court informed of your address. And you have to, of course, pay all the fees that are associated with that program. And then when you do that, some time passes, and then the case gets dismissed like it never happened. That's a really good thing. But in the meantime, you have this plea entered, and in many senses in the law, you do remain convicted of the charge. And so, for instance, if the defendant is subject to state licensing, they can still consider that as misconduct or similar actionable situations, and you can actually have your license affected even while you're participating in DEJ. The odd part, the anomaly in the law, is that once you complete DEJ, then it actually is beneficial for the licensing agency to know that you've completed the program, so that although technically it's still actionable against your license, rarely in my experience, I called them last week and they said that they do consider prior misconduct, but if this is the only thing or it's one of one or two minor things, this just is one more minor thing. It's not a big deal to the state. So DEJ is actually a pretty good program still, although you have to enter a guilty plea, which many people had a problem doing in the old days. You know, in talking about these programs, what I wanted to also stress is the participation that's required from the person taking the program. In DEJ, there's approximately a 12 or 16-week program, which is usual to start with. The testing requirement to provide urine is almost completely random once you complete that program. The primary providers in Nevada County do have mandatory urine testing while you're taking their program during that 4-month period. However, once that class is completed, the intrusion into the person's life is really minimal. In Prop 36, there's a lot more participation, and in the drug court program, which some counties call Track 3, there's a lot more participation for a longer period of time. But the DEJ is seen by many people as kind of a long rope, which if a person has a serious drug addiction problem, you know, it's kind of hard for that person unless they're really seeking treatment and really have a lot of insight as to their illness. It's really difficult for that person to get as much benefit compared with an occasional or recreational drug user that just happens to have bad luck and get caught. If you receive a dirty test in DEJ, or you commit a new offense in DEJ, or you fail to complete the program or pay the fees, that's a violation of DEJ, for instance. When that happens, the court will file some paperwork and send you a copy in the mail requiring you to come to court. To a defendant or a participant in the program, that looks a lot like a violation of probation. The law treats it quite similar to that, and when the person comes to court, they have the right to an attorney, they have a right to a hearing in front of the judge to see if the charge is true. If the judge finds that the charge is true, the judge can terminate the person from DEJ, reinstate them into DEJ with new conditions, or impose sentence under certain conditions. The primary difference between imposing sentence and terminating the person from DEJ is that if the sentence is imposed, that implies that you go to jail, go directly to jail, whereas if you just terminate DEJ, there's a chance that the person can slide over into more intensive treatment in Prop 36 or participate in other drug court programs, depending on what the nature of the violation is, in order to still try to get the charge dismissed, or in order to get more beneficial treatment, really, is really what we're talking about. So there's still two chances: that's get back into the program of DEJ or slide over into Prop 36, for instance, for the person to kind of have a second or third chance. In Prop 36, again, you have to enter a plea of guilty in order to participate in Prop 36. In Prop 36, the difference is you're actually evaluated individually by a behavioral health employee who has specific training and certification in drug addiction and certain mental illness. That person will come back with a recommendation to the drug court team, and then the drug court team will gather and decide really what the program of treatment will be for the participant in Prop 36. So, again, to sort of contrast DEJ and Prop 36, DEJ is more like a mail order course where you just kind of go through it, get whatever benefits you can out of it, and move on with your life. If you have a need for treatment, DEJ really doesn't have the funding or the expertise associated with it to really do much more than point you in the right direction of some community services and social services which can help you out. Whereas Prop 36 is much, much more hands-on, and it's really sort of the meat and potatoes of all these alternative court programs. Prop 36, you can be convicted, so to speak, because, as I said, you have to enter a guilty plea, and the court in Prop 36 actually does admit you to a grant of probation. And so legally you look exactly like a person who is on probation. But it's a special kind of probation that really avoids incarceration as the primary punishment. And it's actually quite difficult to incarcerate or lock up a participant on Prop 36. The law has built into it sort of what I would call a fudge factor, so that, for instance, if a participant tests dirty, meaning a positive drug screen, then what they'll do is they'll often pick the person up at home, put them in jail, they'll spend the night in jail, and then the person will come before the court as soon as possible. Obviously, if there's a weekend a person sits, a judge is required to at least look at the incarceration. But the fudge factor is built into the law in an area that they call re-examination of treatment. And so while you're re-examining the level of treatment that the participant is providing, often courts in jurisdictions and counties, including ours, will use the day or two available to them to keep the participant locked up and then impose a sanction, they call it, of the law requires that they give them credit for that jail time, and then they usually step up their level of counseling. And if you look at your handout under DEJ, you'll see, under Prop 36, you'll see that really, a person has an awful lot of stuff to do in Prop 36. In the requirements section on page 4, for instance, for 12 months, you start off with maybe 3 or 4 meetings, so what they call self-help meetings a week. You also go to counseling out at behavioral health, and you're also required to be in court, generally on a weekly or bi-weekly basis for the first 3 to 6 months. That will taper off. But oftentimes participants have problems with employment, resuming education, other commitments that they have that they're unable to meet because of the requirements that the court imposes as part of Prop 36. So the way that looks to people that are participating or watching is that the participant will come in to the team, which is about 10 or 12 people, and I'll talk more about that in a minute, and the person will complain, I can't work, I can't maintain a job because of absences, because of all this stuff. And so what I want to just say out loud at this seminar is that there's a tension built into this system where the court and the drug court team actually often end up going out into the community and kind of informally almost saying, hey, look, you guys, you have this employee working for you who's also being required to do all of this stuff with us. And this person has given their permission for us to come and talk to you about this, and we're hopeful that you can find a way to work around our requirements and will accommodate the participant. And you know, in my experience here locally in Nevada County, often the truth is that employers are willing to work with the courts and with the system. So, you know, what I try to do when I'm participating or talking to people that are participating is I really encourage them, once they're in the program of Prop 36, to be open and honest with everybody they get a chance to be open and honest with. They'll see a probation officer a lot. They'll see their behavioral health coordinator and counselors a lot. And all of those people are part of the drug court team and will funnel the information to the team. The team will meet previous to court, and they'll actually discuss each and every case, and they actually discuss all these little things that are going on in these people's lives. So my experience with this program is that really we're very fortunate to have the people on the team that we have, and we're very fortunate to have good cooperation and good information. But the participant doesn't always feel that. And the participant, in my view, really needs to be encouraged to come forth with this information and be as open as possible. I guess what I want to do next is just turn to the third kind of drug court program, which our county really, calls drug court. We used to call it Track 3. Many counties still call it Track 3. That's come to be a very, very sort of mysterious, nebulous court. The people that participate in that are almost without exception multiple offenders who have a history of longer term anyway, incarceration of months or several years. These folks are usually people that would often typically not get a chance at another grant of probation, but the court would really want to lock them up for public safety standards, or just because the person doesn't seem to be really interested in modifying their behavior, really. And so the probation department, especially here in Nevada County, will have already had multiple cracks, so to speak, at these people. And just, they're kind of people that generally the probation department will recommend that we do not take a chance on this person. However, the defense attorney and the judge, sometimes even the district attorney, are willing to come forward and say, Your Honor, I know we should be sending this guy or girl to prison. However, in this circumstance, for these reasons, they really seem like they could benefit from treatment one more time. And so in Track 3 drug court, or what we call drug court, these folks really get their shot. And it truly is kind of a last-ditch effort. You don't have the statutory protections that you do in Prop 36 or DEJ, and if you violate any term or condition of your probation, the promise is we will send you to prison unless there's a dang good reason not to. And so these folks are just really walking a tightrope. The drug court program here also has, in my view, a pretty good track record. You can get the statistics through the court administrators, but what I want to stress is that the people that make it to drug court in Nevada County are oftentimes people that I've seen in and out of the public defender's office during the entire 26 years that I've been here. They have children who have grown up. Sometimes they're involved in the system in some way with CPS, for instance, or with the juvenile system. And these are the parents of those kids that are seeing that there's something fundamentally wrong with their lives. They're seeing that the way that they live their life just has failed to work out. And so they're becoming at an age where they just do not want to fight, do not want to run. They'd really like to search out a way to not be locked up for the rest of their life on the installment plan. And so you get a group of people that are participating in drug court who tend to be, again, there's exceptions, but they tend to be very motivated group of people. So they keep these people together, and they keep them oftentimes with similarly situated, like the drug court team, the Prop 36 team tends to have some overlap in who's on it. And they psych these people up, and they motivate these people, and they keep them involved and participating in their recovery from alcohol and drug abuse, and also in learning actually how to live their lives away from committing crimes. Because believe it or not, some people really never learn that. And so this is really, again, what I want to stress is that I was I became a lawyer at a time when California had just passed a thing called Prop 8. And Prop 8 took the focus of criminal law from rehabilitating the offender as if they were a member of society that needs to be helped and educated and trained. And it really said these are outcasts from society, these people, and they really need to be segregated from society, and they really need to be punished. And so as an attorney, I grew up, so to speak, in this system that was really primarily focused on punishment or punitive measures. And now, for the first time in my career, I'm seeing this shift slowly, but in a large way, away from that model to, again, try to accept these folks as if they were our neighbors, which often, as a practical matter, they are, especially in a small town. So I think this stuff is great. I know a lot of the people in drug court, so I can't pretend to be neutral about it, and so I can offer my personal opinion that it's a great program. However, it's got a really short little paragraph in the handout, and that's because, again, this is not what the law has done in California is recognize that all three of these things are a collaboration, and this is the first time in the law that, at least in California, and really it's the first time anywhere since the 90s. Basically, the California website talks about Florida. It was tried in a couple other places in the 80s, but basically since the 80s and 90s. This collaborative process brings together members from the defense bar, the prosecution, the courts, so you have all three participants in the courtroom. Law enforcement is often involved, probation is involved, the supervisory people, and also the treatment, the health, physical health as well as emotional and mental health systems are brought together around literally this table in this courtroom. And they all have their own little files, and there's papers piled up everywhere, and you get all these, people paid a lot of money with a lot of pieces of paper to hang up on their walls, and they're all talking about these folks and what's going on in their lives. Now, part of me wants to say, what a terrible intrusion. But the other part of me that it has to stand up next to these folks as they go through the criminal justice system time and time again says, look, I know that we're intruding in their privacy, but the balance or the payoff is that the system spends less money, less resources, less trauma. The community has these folks in treatment instead of hanging out, causing trouble in the parks, or, if you have a racetrack in your community, they're involved in other activities. And so the payoff is for one thing, it's more difficult for them. They have less time to commit crimes. And for another thing, they're actually learning how to live their lives hours at a time without drugs or alcohol or criminal excitement. And so this is a small segment of our population that we're talking about too, even if you combine all three of these drug court programs. The collaborative system is really talking about delivering services to these people, including incarceration, even in state prison. But they're experimenting really for the first time, and I think it's a wonderful experiment, and I have a lot of hope for it because I'm tired of seeing the other stuff, frankly. But also I see that it works. I see that it works. There's people who really are no longer as depressed about life as they were even a couple of years ago. So that's pretty much an overview of the adult system. And I'm just looking at the time to make sure we stay within our bounds. The juvenile system is also, there's a statutory language that creates a juvenile drug court, both for offenders as well as for the dependency law, which is where we try to help kids that are in sick or abusive or criminal households. The juvenile system, however, again, the law is rather nebulous. In other words, it's not as clearly defined, for instance, as Prop 36 is. And therefore, there's a lot more discretion involved. You know, in a lot of ways, the way that that system is evolving is that they're finding out as they actually create the system and then participate in the system what the needs are and what the benefits are, and they're finding out, unfortunately, what the costs are, so that the juvenile systems, especially relating to these court programs, are really often underfunded and under-participated in. In Nevada County, again, we're real fortunate because a lot of the drug court team in Prop 36 overlaps into adult drug court, you know, the Track 3 stuff, and they also participate in the juvenile system. And so you have either the same person or a person working closely with that person, and you have that same motivation. And luckily, in my view, and I know nobody's going to watch the tape, so I'll say this out loud, you have the same expectations, so that there's relatively more money in Prop 36, there's relatively more services being delivered to Prop 36 folks. And then you got the juvenile court, probation officer, for instance, or mental health worker, or just pick one of them, and saying, well, how come we're not doing that same thing with the kids? Well, why don't we try this? Because they're doing it over there. And so you have this kind of pull to develop a fuller system and a richer system down in the juvenile, or up in the juvenile departments. And so, again, at least in Nevada County, the funding is still an issue, honestly, but there's a lot of interest and a lot of thought being put into these programs for the kids too. So the juvenile drug court for offenders, it starts just like any other kid that commits a crime. They file a petition in juvenile court asking the juvenile court to make the kid a ward of the court. And wardship is really basically where the court becomes a parent between the kid and their actual parents or guardians. And the court sits as if it were the only really parent, and the parents lose their legal right to say exactly what happens to their own kid. Wardship can be very intrusive, but again, the system has built into it through court decisions and other explanatory laws, a whole system of ratcheting up the intrusiveness, the primary one of which is the public defender, who's here today, will represent the interests of the kid and will advocate on behalf of the kid, and often as a practical matter, the parents also talk to the attorney, and the attorney considers the best interests of the child in relationship to what's going on in the family, and has a lot more leeway than as an adult, the same lawyer handling adult cases, to really do what's best for the kid and to advocate for what's best for the kid. The court system itself is set up exactly for that purpose, and the DAs know that, the probation officers know that. And so the drug court system, again, is a fairly informal system in juvenile court, whereby the kid can really have whatever crime brings them into the court. If it's seen that the kid has a drug problem and is not otherwise violent or acting out in other criminal ways, then the kid will be offered a shot at drug court, or the kid can ask for drug court. The primary thing, if this applies to you in your real life, is to keep in mind that as a parent or a guardian of a child participating in drug court, you really have an awful lot of obligations and participation as well, and your time will be eaten up as your child is sitting in the actual courtroom. Dependency drug court is similar to adult Prop 36 court. These are the cases where generally parents have a drug problem and their children are acting out or otherwise come to the attention of the CPS system, and they're taken away from the parents for a brief period of time. The parents will be offered a chance to participate in drug court as an adjunct or an addition to other services or requirements in order to get their kid back in their life fully and to get CPS and the juvenile court out of their lives. The parents that participate in the drug court, again, tend to be folks who have not been caught committing crimes that would make them eligible for Prop 36, or they're otherwise ineligible for Prop 36 because of multiple offenses or the wrong kinds of offenses. However, in kind of an interest in keeping families together and returning them and getting them back together, these services are offered to the parents to really help them out and give them, again, another chance. The stick, so to speak, the carrot, of course, being we'll get out of your life, we'll leave you alone, and you have a good life. The stick is, you guys, don't you understand, we can take your kid out of your house if you guys are shooting drugs in front of your kids and nodding out and not cooking them dinner, or cooking them dinner and leaving the pot boiling on the stove and creating a fire hazard or other hazard. So, look, you guys, just why don't you participate in drug court as an option to the services? Now, sometimes, to be honest with you, I kind of wonder why the parents will participate in that kind of a dependency drug court. And really, the answer to that comes often when I ask, they want help, believe it or not. The parents actually want to get help. They don't have a clue how to get help. They don't want to burn down their house or endanger their kids any more than I do. They've been caught often in a compromising situation they can't explain their way out of. I know this looks bad, Mr. Walker, but I had a drug problem and I know I was going to burn the house down. I'm really glad this happened. And so they'll volunteer mostly for this dependency drug court. In other cases, it's fairly coercive. There are criminal charges which are withheld by the district attorney as an additional reason to get involved in dependency drug court. There's hope for a quicker reunification with the children, and other things that are used informally as kind of what really amounts to coercion. But again, the parents always have an attorney. Oftentimes, each parent will have a separate and independent attorney to represent their individual interests in this. And they're not really allowed to do anything without consulting with the attorney, and without the attorney at least having explained the ins and outs of these programs and their options. And so the law, again, has built in these safeguards, which it's a new system, but so far that's not where the complaints occur. Again, the complaints that I hear tend to occur in inadequate levels of service, which I know to be funding issues, and just the inconvenience. It's interfering with the rest of my life, and that's of course, easier to conceptualize with someone as to, would you rather lose your kid or would you rather sit in court for a few hours? There's also non-court programs that are an alternative to incarceration, and I wanted to just hit a couple of those. I don't know how much interest there is. The schools in Nevada County operate under the Education Code of California, and the Education Code of California back in the 80s instituted a zero tolerance policy for drug use. Nobody was happy with that, to be honest with you. The schools weren't happy with it. Parents were singularly unhappy with it. And the schools were really unhappy because if you have a straight A student that is caught experimenting with marijuana in a bathroom stall, the teachers really don't want to kick the kid out, and the administration certainly doesn't want to lose a straight A student. And so over the years, the legislature has passed a law here and there to sort of soften the zero tolerance policy. And really what they've done is they've built in, again, a fairly mysterious, if you're looking for rigid rules, you ain't going to find it here either. Because what they've done is they've built in some flexibility for the schools to handle some of these incidents on campus. And they actually trust, I know this is hard to believe, but they actually trust the administrators of the school to kind of use their judgment as to whether you have a drug-dealing, psychopathic kid with serious problems or whether you have a straight A student taking a couple puffs off a marijuana cigarette. And so what I want to say at this juncture is that Terry McAteer and those guys have really allowed the individual smaller school districts in our community to come up with their own policies. The high schools actually have different policies from high school to high school. And then what I say in the outline diplomatically as possible is that these policies are very case specific. So the folks will look at the kid and the adults that come in with the kid and see kind of what cooperation there is and what needs there may be. It's not an exact science at all, but they also have a 12 or 16 hour week diversion class that they offer, and it's an 8 hour, I guess. At least it was not just one finger that was held up, so it's 8 hours. It varies. It's varied over the years, but they do allow that on campus, and of course the campus administrator has so much discretion or leeway. They sit there with the little policy that says zero tolerance shall be expelled, deported or whatever they are. And so they have a lot of power in this discussion. So often, again, parents will raise these issues in terms of what's fair and what's legal. Pretty much anything short of expulsion is negotiable with the school districts, depending on what they want to offer. So they pretty much are holding all the cards. I have a section on medical marijuana. That's really, read it. I wrote some good stuff in medical marijuana. Basically, there's a lot of controversy about medical marijuana. Currently, you are not allowed to use medical marijuana at all if you're in a drug court. I don't know that it will always be that way. That varies from county to county. There's no legal requirement requiring that a drug court require abstention from medical marijuana or opiates or any particular drug for that matter. And so it's really what my view is, it's what will the community bear? What will the community tolerate? So far, there really hasn't been any great cry for allowing these folks to use their medical marijuana except from folks that have a recommendation to smoke marijuana and want to be in court. And so until such time that there's the political will to change the status quo, then we're going to be faced with the status quo. The good news is that because medical marijuana is not really well researched yet in the medical community, there are a lot of alternatives that doctors have decades of training in to offer a patient that is not, for one reason or another, able to tolerate or legally allowed to use marijuana. So that the feeling tends to be among medical professionals that I've had to call as witnesses in court, the feeling tends to be that there are enough other alternatives to medical marijuana that are just as useful and just as practical that that this is not, in that sense, an unreasonable requirement on these folks, so that it's not cruel and unusual punishment, for instance. Local private providers on page 8 of your handout. There are 2 now in our county. Forever and a day, in the old days, there was just one that's had several names over the years. It's currently called Community Recovery Resources. They receive Medi-Cal funding. They're very hooked into all the county departments because for, probably 30 years, they've been the only provider in town. In the last several years, a second provider, Common Goals, has started in Nevada City and is offering many of the same programs that CORE offers. Many times clients of mine do not have a lot of money to pay private providers, and so they're limited somewhat to using Medi-Cal. And so you should be, you would want to know that, for instance, currently CORE does take Medi-Cal, and Common Goals is in the process of obtaining authorization to accept Medi-Cal. When they do that, they'll be providing the same services that CORE does. CORE also is branching out, and I guess I put that on page 9 of your handout. They have started to offer some transitional living and clean and sober living situations, and those can qualify as inpatient treatment under certain circumstances in all of these drug court programs. Basically what that is the person will live at the clean and sober house, participate in testing, search and seizure of their property in the house. They're subject to rules of behavior, curfews, requirements of work, requirements of schooling, participation in medical treatment that might be required. And basically that's seen as a short or medium-term solution of transitioning an alcohol or drug-dependent person back into unsupervised community life and complete freedom. So those clean and sober living houses are really a good stopgap that really have not been available in Nevada County until very recently. There are also a few private, I guess I should say private, clean and sober living houses that are licensed or certified by the state of California. However, those are, you got to find out about those mostly from word of mouth. Some are for battered women or victims of sexual assaults. Some are for parolees or probationers. And so if you're interested in learning more information about that, actually there's a church here locally that runs a couple of them too. But the best place to find out information about those particular homes is through the group called DVSAC, which is Domestic Violence and Sexual Assault Coalition. It's in your handout here in Grass Valley. The parole office, if the person that you're interested in has a criminal case pending or in their past, or the probation department here can also steer you in that, and also out at Behavioral Health, they can provide you that same information. In terms of outpatient providers, I also wanted to note, I mistyped Sun Valley, which is referred to on page 8, is actually in real life called Sun Creek. They're a relatively new provider here in our county, although they've been providing batters and anger management programs to the courts for years and years, and they're a kind of a franchise. Man Alive is getting to be a similar franchise. It's based on a program that was started in the South Bay area back in the 80s. It's generally considered a really good program. They've got a 52-week program as well as a shorter anger management program. And DVSAC also provides, at times, programs for offenders, although basically their impetus or their concentration obviously is on the victims and the battered women, whether or not they're offenders and other. I also have a section on self-help programs. All of the drug court programs talk about self-help requirements, and I wanted to at least throw in something about the self-help requirements. They generally break down into 12-step programs and private counselors. And I just wanted to sort of introduce the knowledge to anybody that's interested in this area that 12-step programs vary greatly. They have all kinds of different names. Sometimes people think that any 12-step, any program with the initials that have an A in them, all the anonymous programs, would be acceptable as a self-help program. But really what the courts and the teams are looking for are those programs which focus on drugs and or alcohol. And there's so many anonymous programs. I've referred to just a couple, and I think I settled on OA, which stands for Overeaters Anonymous, and SLA, which stands for Sex and Love Addicts. You know, those things are great programs, probably. I don't know, but they're definitely 12-step programs, but the courts probably would not accept them as self-help for drug or alcohol addicts. They would, of course, accept AA or NA, so Alcoholics Anonymous or Narcotics Anonymous. Again, for a complete list, there's 800 numbers here at the courthouse. They have brochures and schedules for all these programs that we've discussed here briefly. The court, the last thing I wanted to cover is the courts have a process once you're participating in one of the court programs of either graduating you or terminating you is how you get out of the system. If you graduate, what you've done is you've completed all the agreements, requirements, contracts, impositions that have been given you from the get-go. If you've had any faltering steps along the way, you've completed any new requirements for community service or additional counseling, you've shown proof to the court, you've paid your tab, and the books are cleared. When the books are cleared in DEJ, they dismiss the case like it never happened. And when the books are cleared in Prop 36, they terminate you from the program. You may still have some probation that may be supervised or it may be informal, depending on the case. At the successful completion of all those requirements, in other words, the drug court requirements as well as the probation or parole requirements, probation requirements, I'm sorry, not parole, the case will be dismissed pursuant to this other section called 1203.4. That's not quite as good a quality of dismissal because it still shows people that look for your case that you were once convicted of something and then it was dismissed. 1203.4 means that, for instance. It doesn't mean that it was dismissed like it never happened. And the Track 3 or the drug court program, the most serious one, that actually it remains as a conviction. You're truly just given one last ditch effort at rehabilitation and treatment in lieu of locking you up for years and years at a time. So that's the ultimate payoff. Lastly, what I did, the District Attorney of Nevada County has just issued a new one-page, very terse, and I don't know what else to say about it except here we go again. The District Attorney has just released their current allowable amounts of marijuana and circumstances of storage and distribution letter. What I have to, advise anybody about that subject is that the local, and I put this, I think, pretty clearly in your typed information, the local communities are free to do whatever the heck they want. Sometimes the local community will try to legislate or pass laws that pretend to affect state law. It's just not legal. They can pass whatever they want to pass until it's challenged in the courts. So the district attorney's policy, for instance, in Nevada County does not enact a law, it does not explain a law, it does not define a law, and it in no way modifies the law. And if you read what they say carefully, it's full of what lawyers call weasel words that are little hidden traps or hidden outs for the DA to say, ah, yes, but did you read this? You know, and so again, what I tell clients and what I caution the public is just follow the recommendation. If you do have a recommendation for marijuana, you know if you're getting close to the line. If you do get close to the line, just be careful and be ready to pay the price, and then hire a good lawyer. All right, thank you. That's all I have. If y'all have questions, I'll turn it over to you for now. Thanks for your attention. Thanks.
I have a question.
Yeah.
Are for people whose abusive drug of choice is alcohol, are the same programs, the same facilities in play there, or?
That's actually a good question. The answer explicitly is no. They're not the same programs. Drug court and Prop 36 is just for chemical substance abuse issues. You can also have a coexisting addiction to other substances, but the qualifying, you have to prove that you have a qualifying addiction, which would be a chemical substance. The Track 3 drug court, the juvenile drug court, and the dependency drug court are much more flexible, both with regard to how you get in, and then also what they offer in the way of services once you're in the program. But the law actually still is geared toward punishment, mostly for alcohol, in my opinion anyway. And a lot of that has to do with DUIs, so that if you have a DUI, a driving under the influence case, or anything related to that area, these programs are not available to you directly. You can sometimes get into them in another fashion. There's a mental health court currently that they're starting a dual diagnosis, or sometimes called a co-occurring disorder court, which will be starting. And some of those folks have DUIs coupled with other substance abuse issues, and they're not getting denied treatment just because they have a DUI or an alcohol addiction. But it's really difficult, if not impossible, to get a chronic drunk, like a person that chronically gets arrested for drunk in public, like the town drunk in the movies. It's really very difficult to get that person into a drug court. So what they do is they give them a formal probation grant, often, and require inpatient treatment at Progress House or one of the other inpatient treatment facilities, and require tons and tons of 12-step meetings and participation. That's maybe the next frontier, I hope. Okay. Any other questions? Yes.
As a landlord, what kind of risk or responsibility, anything you need to look out for if I suspect my tenant's growing, my landlord ready to follow any guidelines?
Yeah, what I want to say about that first is, so in that sense, your tenant could not come back with you, against you, the landlord, and prevail in court. And then I guess what I'm trying to say is that as a practical matter, if you participate in criminal behavior on your premises, or if you're aware and do nothing about it, if you actually have, in other words, if you have actual knowledge of criminal behavior on your premises and do nothing about it, then a good, careful, prudent lawyer would advise you that you have some liability there, and you really need to consider taking some affirmative action to stop the criminal conduct. But again, I feel uncomfortable going too far out in that realm. I mean, it's definitely something to discuss with a lawyer with the Self-Help Legal Center here.
So we have a lot of landlords call and say, okay, my tenants are growing the pot plants on the...
As truthfully as I can, I don't have any experience in that area. what the recommendation is a defense to a criminal action, saying that you have no right to have this controlled substance. And so, in that sense, a recommendation is no more permissive than a prescription to carry around codeine. If I know that you're carrying around codeine in somebody else's prescription bottle, there's no requirement in the law that I tell on you or get you in trouble. The difference with a landlord is that the landlord would be concerned about economic issues, right? And what I could say is that even conservatively, what I could say is that the landlord wouldn't incur liability for instituting an eviction proceeding, because the landlord is not the expert in the marijuana script, and is not required to be. And so in the sense of the punitive aspects of evicting somebody, whether or not the court would agree that they should be evicted, again, the tenant may move out. And if the tenant moves out, this is all a boring discussion. If the tenant fights it, then the landlord really is concerned, do I still get rid of them, or do I get punished, and do I have to do more stuff to get rid of them? And really, I can't imagine any judge saying that you acted wrongly against your tenant by questioning their script. That's just, it's possible. But again, that's why I was kind of making faces earlier, and you can tell I'm still making faces, because I know that I'm uncomfortable with really trying to paint with too broad a brush here. I'd really, as their lawyer, first of all, not having experience in this area, I'd have to either seek advice or get educated about it specifically based on my general knowledge of landlord-tenant law. You would incur some possible liability, but I think it's so small or so low that I'm inclined to say you don't really have much exposure. Now again, if you start telling me there's 500 plants on a quarter acre of land and they're 12 feet high and the helicopters are circling and I'm doing nothing, there's 4-year-olds from next door playing in the, on and on. If the more facts, the more I might change my mind. Yeah, and again, it's not a black or white answer. If in case somebody's watching the tape and didn't hear, the answer was if you stay within the published limits, as much as I might dislike them, that the DA has just published, then, for instance, officers serving a search warrant or probation officers supervising people already on probation would not be inclined to think that the landlord is up to any no good stuff. But if the activity at the premises is obvious, blatant, over the top, exaggerated, those kinds of thoughts, then the more likely it is that the police or the probation department or, other agencies can get involved for safety reasons, believe it or not, even the fire department sometimes. But, then it becomes an issue. And the landlord really ought to take some affirmative steps to protect their rights. It's not really so much a question of getting anybody in trouble. It's just, I want to protect my property, and I didn't bargain for, this marijuana crop in my backyard in the middle of downtown Grass Valley.
Most of them get concerned when it's, hydroponic in the house and mold and stuff, that they're concerned about the mold infestation, damage to the house itself.
Sure. So, what I would recommend is you handle that in exactly the same way as you, the landlord, would handle any other situation that you think they're damaging your property. It's no different just because it has something to do with their medical condition. It's not an ADA, Americans with Disabilities Act, kind of issue. Might be one day, but right now it's not. Do you have another question?
In the past, I have a case, I have no evidence, but the neighbor would call and say, hey, your tenant has a lot of traffic coming and going, and we suspect she's stealing. But I have no evidence it wasn't on you.
Yeah, you can, what I want to say is you're free to do whatever you want to do. You can mind your own business. You can call probation. You can call the police. You can call the sheriff. Just if, what I would do as a landlord, I think, is tell the person giving me that information, I haven't seen this, why don't you call? Why don't you call? Again, if the question is, what pressure does society put on you to become involved in other people's lives, your landlord interest is to protect your premises, protect your legal rights, and your economic investment. The law absolutely does not place upon you any burden of policing people in your apartment. Again, in some limited areas of the country, local laws are somewhat different. But in California is more of a Wild West state in that regard, and so we're not as inclined to have posses riding around looking in people's backyards. Anyway, I'm sorry. Basically, if it's bugging you, do something about it.
If I would like to ask her to move, what kind of reason I can tell her that please leave my house?
Well, don't forget, you can always ask. If you have 30 days, if you're on a month-to-month, you can give 30 days and no reason.
No reason.
Correct. If there's a lease, there may be other items in the lease that give you the right to do so. Yes. Ma'am.
Would you say the alternative courts are more successful in rehabilitation than the straight incarceration?
Well, yes, I would say that. However, in all fairness, I have a lot of time invested into both systems. And I'm speaking from what I observe as a defense attorney, seeing how many guys get, generic people get probation, and later on get terminated and sentenced to prison, versus how many folks get a drug court and successfully complete the drug court. The regular courts, so to speak, have really been moving toward more and more treatment in the last 10 or so years anyway. And so I think that is, although there's you don't hear political speeches about it or articles written about it, I believe that's because that Prop 8 philosophy of punish them, squish them, kick them out, deport them, send them to an island, just it isn't very, it's not very successful in the long term, and it's also not a very happy way to say, come and live in beautiful California, it's a peaceful place. And so I think that as time passes and we gain experience with the punitive nature of our system, we start to turn away from it. And I think the alternative courts are growing out of that turning back toward the center, I would argue. Although some people might disagree with me, but they'd be wrong. And moving back toward the center of let's punish where we have to, let's help, because that's mostly what people want, need. It's a more optimistic way. And so, long-winded answer of saying, yeah, alternative courts are just really, really good, really successful. They're a good way to spend money. They're cheap compared to incarceration. It's great. I think they're great. Sir?
You say as a treatment provider, the success rate.
And again, for the tape, that's one of the treatment providers' opinion is stated even stronger than I did, which is that chance to learn a new way of life that's never been offered to that person before is something that many, if not most, of those folks will move toward and away from a criminal and substance-dependent lifestyle. Any other questions? Thank you very much.